Well, I do believe I am live right now. I think I'm right. So, welcome everyone to this session here. My name is Lior Samfiru. I'm the employment lawyer. You know that. You've seen me before, I think. And why am I here? Well, you know that as well. I am here to answer your questions about employment law, about workplace rights, to help you understand those important issues. I'm one of the founding partners of Samfiru Tumarkin LLP. We operate in Ontario, in BC, and in Alberta. We help people across the country with those employment law issues. So if you're dealing with a workplace issue, a problem, maybe you're dealing with an ultimatum, maybe you lost your job, maybe you're losing your job, maybe your boss did something, you're just not sure if it's legal, your job is changing, you're being mistreated, I can go on. If any of that applies to you or anything at all to do with your job, ask the question. Ask me now, what do I do? Ask me, is this legal? Ask me and I'll tell you. I'll give you that information and you can walk away, of course, with those answers so that you know better, so you don't stress out unnecessarily. And I say unnecessarily because we actually have really good laws, employment laws across Canada. Many people don't understand what they are. Well, by listening to this session like you do every week, you'll know more about those rights. You'll understand more. You'll know what to do and how to respond if you're dealing with a workplace problem. And let me give you some other contact information. If you want to learn more about employment law, or if you want to take the next step, which is to connect with me off social media to have an email exchange or a phone discussion, easy to do. You just go to employmentlawyer.ca. You see that address on the screen below, employmentlawyer.ca. You can read about employment law. You can get my phone number there, my email address. You can fill out a form if you prefer. It's all there. Employmentlawyer.ca is kind of your one-stop shop when it comes to employment law and resolving those workplace issues. But that's for later. Right now, for the next 30 minutes or so, I'm live and I'm waiting for your questions. Always, every single week. When I do this, I always get questions the last few minutes, and sometimes I don't get to answer them. So right now you have time. There's no rush. You can take your time, sip your coffee, ask the question, and I'll get to it and I'll answer it. So again, my name is Lior Samfiru. I'm one of the founding partners of Samfiru Tumarkin LLP. We practice employment law, the biggest employment law firm in this country of ours. And right now I'm here for you at your service, answering questions. Well, we know that. So let's get going with it. I'm going to start answering some questions right now, but don't wait. Type in, press enter. I'll see it and I'll answer it. First question from our regular viewer, N. Stinson. Employment agreement has clause limiting severance to terms outlined in company policy, which in some cases amounts to 50% of common law. Is employee bound to the policy they signed? So here's the thing. Employers often try to limit severance. And with an employment agreement, an employer can potentially limit severance to a lot less than 50%. It could be 2% of what full entitlements would be. Here's the thing, though. Our courts have said that in order to properly limit severance, the employment agreement has to say very specific things, A, B, C, D, and say them in a very specific sequence. And if it doesn't do all those things perfectly, then it's not going to be enforceable. It's not going to limit severance. The good news is that a lot of employers don't do a good enough job. They don't get it just right. So even though you may have signed an employment agreement that tries to limit your severance, it may not have the effect of doing that. I'm going to say that more than 3/4 of those agreements that try to limit severance, in fact, don't do that. So obviously, to tell you whether your specific employment agreement does or does not limit your severance, I'd have to see it, right? I'd have to see it and read it, and I'll tell you, yes, it does, or no, it doesn't. So employers try to do that often. Usually 3/4 of the time, they don't do it well enough, which means it doesn't matter. You still get your full severance. That's why it's so important. If you lose your job, even if you think there's an agreement that limits your severance, well, it limits me, so I probably don't get any more. Well, not so fast. Again, most of the time that agreement doesn't properly limit you, so you are owed more. That's why it's so important to give me a call if you lose your job. I don't care who you are. I don't care what you've signed. Okay. Chances are you're going to be legally owed significantly more. Okay. So that's why to do that, contact me always, employmentlawyer.ca. Again, employmentlawyer.ca. All right. Great question. Continuing with questions. See how easy it is? You can do the same thing. Our next question today from Alex on Facebook. My employer terminated my position and has said it was for cause. Would I still be entitled to any severance? I never had any issues prior to this. Well, it is very difficult, extremely difficult for an employer to properly terminate for cause. For the employer to terminate for cause, the employee would have had to do something so bad, so terrible, that it's just not possible to continue employing them. Either that, or there has to be a long history of disciplines, warnings, maybe even suspensions before the company can consider a termination for cause. Now, if the company does in fact have cause, which is really rare, then they don't have to pay severance. If they don't have cause, then they have to pay full severance. So in my experience, whenever a company says they have cause, they haven't actually got to that point yet. They haven't probably built the case, or whatever it is that the employee did is not bad enough to be cause. So in the majority of cases, when someone comes to me with that termination letter, says we're letting you go for cause, it's not really cause. And it could be the difference between getting nothing, getting no severance, and getting 2 years severance. Okay, so that's why you call me always if you're terminated, especially if the company says you don't get any severance because they're terminating you for cause. So Alex, hopefully that answers the question. Happy to chat more. If any follow-up questions, ask right now. All right, let's see. I'm going to continue answering questions. Do you have any successful court decisions in Alberta? Absolutely, we do. Yes, that's from Colcad. Don't know if I'm pronouncing that right. Next question, Rebel. If a job application says you will be on probation for 3 months, is that an enforceable clause? Yes, absolutely. An employer can put you on probation for the first 3 months. What I want you to understand, though, is probation is not automatic. So just because you start a job, you're not on probation automatically. You're only on probation if you sign an employment agreement that says you're on probation. So it has to be created in an employment agreement. It's not automatic. But if your employer presents you a job offer letter or an employment agreement that says you're on probation for the first 3 months, yeah, that's allowed. Really, anything more than 3 months, you're not really on probation. It's meaningless. So even if they try to say it's 4 or 5 months, it doesn't matter. You're not really. But yeah, for 3 months, if you sign something to that effect, then yes, you are on probation. And again, not legally wrong to do that. Let's see. N. Stinson has a follow-up. A long tenure employee resigns to take a new job. New job doesn't work out. An employee is terminated within agreed probationary period. Can't return to old job. What rights does the employee have at that point? And does this happen often? Yeah, of course it happens. So it comes down to that employment agreement. So if the employee signed the job offer letter or an employment agreement with a new employer that properly limits their termination entitlements, in the first 3 months, that employee could potentially be owed nothing. But if it doesn't properly limit entitlements, even in the first 3 months, that employee could be owed 2, 3, 4, 5 months of severance, depending on their age, and the type of job. So even in the first month, 2, 3 months of employment, you can have significant severance entitlements if you lose your job. But again, we want to see that employment agreement. We want to see, does it properly put you on probation? Does it properly limit your severance? Does it not? So that employment agreement is going to be a key piece of document. But just because your employer tries to limit your entitlements does not mean that they've done so successfully. In most cases, as I said before, they haven't. Chances are they have not, which means even in the first month, 2, 3, you do get actually substantial amount of severance. Great questions today. Keep asking them, guys. You see how easy it is. I've been answering questions. I've been going through them fairly quickly. If you have a question, if you want to know about your workplace rights, if you want to understand if your situation is legal, ask right now. Again, my name is Lior Samfiru. Call me the employment lawyer. I am here to tell you what you need to know about employment law, about workplace rights. Live session right here. I am live. This session is live for you, so ask your question. All right, Miranda asked her question. Miranda says, my employer sent me home on suspension before the holidays under false allegations of intoxication. They have not spoken to me since, and I don't know what to do. What are my next steps? Okay, well, first of all, if what your employer did was put you on suspension for false allegations, if it never happened, then clearly the suspension is not legitimate. So you can consider that suspension, if you want, to be a termination of your employment. You can call it a constructive dismissal because it's not legitimate. I'm taking you at your word. So that means you can consider that suspension as a termination and force your employer to pay you severance. If that's what you want to do, call me and we'll get going on that. Now, the other option, of course, is to follow up with your employer and say, hey, I've been on suspension since before the holidays. When am I coming back to work? And see what the response is. If the response is, okay, you can come back next week and you want to go back, fine. If they don't want you back or they don't respond, again, that could be a constructive dismissal. You can call me. So you can treat it as a constructive dismissal now, or you can ask the company for an update and then decide if you want to treat it as a constructive dismissal. But a company generally does not have a right. By the way, even if you were intoxicated, in most cases, the company would not have a right to put you on an unpaid suspension. Okay, so I want you to keep that in mind. And of course, to reach me, Miranda, easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see my phone number there, my email address there. Everything you need is right there. Okay, employmentlawyer.ca. All right, bunch of questions coming. I love that. I'm going to answer them in the order that they came. Next question is from Jacob on Facebook. My employer has decided to close down our brick and mortar location after 23 years and is requiring everyone to work from home. Is this a reasonable request? I've worked there for 5 years and do not have a setup to work from home. Great question. Usually people ask me, I've been working from home. They want me to come into the office. But it's very legitimate to ask, well, I've been working in my employer's location. They want me to now work remotely. Can they do that? No, they cannot. What I mean by that is that's a significant change to the terms of employment. If you were working at an office or at a factory and whatever it is, and now they want you to work from home, that's a significant location. And you don't have to accept it. That means you have two options. Option number one is, yeah, you can accept it and you continue working remotely and no problem. That's option one. Option number two is you can consider this now as a constructive dismissal. Absolutely, you can. You can consider this as a constructive dismissal and treat it as if it's a termination and force them to pay you severance. That's what a constructive dismissal is. So those are the two options. There's no third option. You accept it or you say constructive dismissal. If you want to pursue the constructive dismissal, if you don't want to work from home, you want to just consider this to be a termination and get your severance, you know what to do. You reach out to me. We do that. It's not complicated. You can contact me, of course, through employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the screen right now. Phone number, email address, everything you need to contact me is right there. All right. Questions coming in. I'm happy. All right. Next question on YouTube from The Ray. I'm still on long-term leave and just got notice that the company wants to terminate me without cause. I was given a release form to sign within 5 days. What should I do next? Well, I've been saying this since the session started. You do one thing and one thing only. You contact me, okay? It's literally as simple as that. There's nothing else you can or need or should do. You contact me, okay? You go to employmentlawyer.ca because number one, even if the termination is otherwise legal, we need to understand if what they've offered you is proper. Okay, chances are in over 90% of cases, whatever you've been offered is a small fraction of what you're actually owed. So that's number one. Number two is, well, why were you on a leave? Is it a medical leave? Are they letting you go while on a medical leave, as an example? That could be a human rights violation. So there's other things we need to discuss beyond just the severance offer. And by the way, for you, The Ray, and for anyone else, even if before you call me, if you want to know if what you've been offered is fair, if you want to know right now, if what you've been offered is fair, easy to do. Grab your smartphone, grab your tablet, go to pocketemploymentlawyer.ca. You see that address right there, pocketemploymentlawyer.ca. When you go there, you'll see our severance calculator. Very simple to use. Over 2 million people have used it. Easy, easy, easy. When you go to that severance calculator, you'll answer 3 questions and you'll find out if what you've been offered is fine or not and how much you're actually owed. Not what the company is offering you, not what they want you to accept, what the law says you should have. Again, pocketemploymentlawyer.ca. And by the way, that I mentioned, it's completely free. It's completely anonymous. You don't put in any names. You don't put in your phone number, your email address. It's all there just for your benefit. And if you want, and only if you want, you can even contact me directly from the severance calculator. Okay, so check out pocketemploymentlawyer.ca, The Ray, but you gotta call me. Okay, so reach out and I'll help you out. So let's see. Miranda has a follow-up. Miranda says, I was an assistant manager and our new manager has been making things difficult for me. So again, you can treat this situation. Miranda was put off work for false allegations around the holidays. So you can treat this whole situation as a termination. So again, really only two options. You follow up with the company about going back to work, or you can consider this whole situation as a termination. If that's what you do, that second option, the termination option, you have to give us a call. That's not something you're able to do on your own. You need to give us a call. And to do that, again, employmentlawyer.ca. All right. Next question from Mojo on YouTube. Can your employer offer you gift cards in place of unpaid overtime? No. Full stop. No, they can't. Legally, well, I mean, they can offer you, and if you're happy with it, I guess. I mean, maybe you prefer that. Okay. But legally, can they force you to accept that instead of overtime? Absolutely not. Absolutely not. Okay. No, they have to pay you with money, with Canadian dollars. Okay. So that's what they have to do. Anything less than that is not in accordance with the law, and you do not have to accept it. Okay. So good question there, Mojo. Hopefully that helps. I'm caught up on questions. I'm waiting for some more questions to come in. But I want you to remember, of course, always that you have good rights. Often when people say, "Oh, we don't have good rights here," it's because they don't necessarily appreciate what the law does and what the law says. They're not aware of the full gamut of rights that we have in this country. We actually have really good employment rights, especially if we compare ourselves to our neighbors to the south, where not very good rights there at all. They have something called employment at will in the U.S., which means you can be let go at any time, not get paid anything. You don't have any form of job security, any compensation. Very different in Canada. We do not have that in Canada. Company does have to pay you significant amounts, up to 2 years of pay if they let you go. That doesn't exist in the U.S. Now, in between your questions, and by the way, ask them. I'm going to talk about a few other common questions that I've been getting about termination and severance. But your questions, always a priority. Always a priority. So I'm going to continue answering. New question just came in from Julia. My position is being eliminated from my company. I've been told I will need to move to a new role. I have worked as a supervisor and they now want me to be a salesperson. Do I have to accept? So, Julia, to the extent that instead of a supervisor, salesperson, that's a demotion, presumably, being a salesperson instead of a supervisor, it's a demotion. That could absolutely be a constructive dismissal. That's especially true if it comes with a pay cut. But even if it doesn't come with a pay cut, even if the pay is the same, but one is a more senior role, that demotion could be seen as a constructive dismissal. That means you can choose to consider that demotion as a termination of employment. Now, there's no way to physically stop your employer from demoting you. You can't go in there and then get the police to stop them demoting you. Can't do that. What the constructive dismissal does is it gives you the option to either accept what your employer is doing or to consider that a breach of contract, a termination. And that means they have to pay you severance, okay? So those are the options. No, they can't do that. Even if it's for legitimate reasons. They're not picking on you. They're not trying to hurt you. They've decided to eliminate the position. Fair enough. That still doesn't mean that legally they can force you to accept a demotion. Absolutely not, okay? So if constructive dismissal makes sense to you, if you want to understand how much you're owed, if you want to understand what what's involved, easy to do. Reach out to me. Let's talk. Happy to help you. And Julia or anyone else, again, I've given this before. I'll give it again. If you want to connect with me, very, very, very easy to do. See that address right over here, employmentlawyer.ca. Phone numbers there, email address there. Just give you the website. It's much easier than trying to rattle out a phone number. That's why I give that address, employmentlawyer.ca. For those that have joined us now and wondering what you're watching, you're wondering who I am. Well, my name is Lior Samfiru. I'm the employment lawyer with Samfiru Tumarkin LLP, and I'm here live for one purpose and one purpose only: to educate you about employment law, to answer those questions. So if you have questions, like so many people today have had already, you have about 10 minutes or so to ask those questions. Don't wait till the last minute. Take advantage of the fact that I want to help. I want to give you helpful information. I want to try to solve those problems. I can't do that unless you ask me a question, right? So ask your questions right now, and let's do that. Does employment law cover military employees? That's a question from JC. It does. There's additional rules and different rules that apply specifically to military personnel. There's specific statutes, but yes, employment laws generally do apply to military employees. Question from John on Facebook. My company was just purchased and we have been issued new contracts. I've seen that before. I don't agree with the new contract. What happens if I refuse to sign? Well, the question is, why are you refusing to sign, and what's in that contract that's not favorable to you? So if you just don't want to sign, but it's not a good reason, well, that could be considered potentially a resignation, or you may still be owed some severance, but it's minimal. On the other hand, if there's a good reason as to why you don't want to work for the new company, that the new contracts they offered you is different hours or different pay or other terms that are not favorable, you don't have to sign it. You don't have to accept it. And if as a result of that, you lose your job, you get your full severance. It's not a resignation. Okay. So if you have a good reason, full entitlements. If you don't have a good reason, maybe no entitlements or very limited entitlements. So my best advice is this: before you make a decision, before you tell the company, yes, I'm signing, or no, I'm not signing, call me. Let me see the agreement. Let me tell you what I think about it. Let me understand what concerns you have, and then we'll decide exactly what makes the most sense for you. And of course, to reach out to me, I've said that before, but here it is again, employmentlawyer.ca. Again, employmentlawyer.ca. So JC, am I considered an employee if I'm on an unpaid internship? Do I have the same rights? What rights do I have? So if you're truly on an unpaid internship, then you're not an employee, right? And employment laws only apply to employees. Well, the thing though to understand is you want to make sure that you haven't been misclassified. If it's a situation where you're providing value by not really getting value, the law is going to consider you to be an employee, right? And because of that, if you're an employee, you have the rights of an employee and also the right to get paid. You can't just have someone work for free. But if the internship is really more for your benefit, the company you work for or the employer is not getting too much value, then it's an internship and they don't have to pay. And the employment laws kind of stay away from that, right? So the question is it a real internship or is it an internship in name only? So if I have someone, let's say I have a factory and I need someone to work in my factory, and I hire them and I say, you know what, I'm not going to pay you. You're just going to be an intern, unpaid internship. So, work in my factory. Well, that's an employee. They work in my factory. They provide value. So I've misclassified them. That's illegal, right? So if that's your situation, it may be illegal. If it's a situation where you're getting value, then yeah, it's potentially fine, and there's no employment laws that would apply then. Great questions. I haven't gotten that internship question in a long time, so it's a very good question. All right, YouTube, another question from Glendon. My employer has missed the last 2 weeks of payment and hasn't said anything about getting caught up. Am I still considered employed if they are no longer paying me? So no, you're not. And employment the employment relationship, actually, if you think about it, is fairly simple. You go to work, you get paid for your work. That's it. It's as simple as that, right? Well, if the employer is not meeting their end of the deal, they're not paying you, well, then there's no employment relationship. You can't work for a company if you don't go to work. You can't work for a company if you don't get paid for your work, right? It goes both ways. So you can continue working for free, I guess, if you want. I mean, it's not legal. Or you can say, no, wait a second. You broke the deal. The deal you were going to pay me on time, the amount that we've agreed on. You broke the deal. It's such a fundamental term that you've broken. So now I've been terminated. Now, by the way, you also have to pay me severance because you can't just terminate me without severance. Again, this concept of constructive dismissal comes up again. So very important. If you're not getting paid, that's not legal. Okay, you have to get paid. Julia, next question on YouTube. Julia asks, would starting a new position mean that my seniority starts fresh, or would I carry over from my other position? Well, if it's an unrelated company, you quit one company and you join another company, then it starts fresh. If it's a sale of a business, so let's say you work for a company and that company is sold to another company and you continue working with that new company, then yes, in most cases, they automatically inherit your service. But if you simply had a job, you're no longer working there, you quit or you were let go, and then you applied and you got a job somewhere else, then seniority starts at 0. Okay, they don't have to recognize your seniority. Again, as long as the companies are not related, there's no sale, there's no transaction between them. If they're completely separate and you start a separate job, you don't have credit for that previous seniority. You do want to pay attention to that employment agreement that you're going to be asked to sign. You want to make sure that there's nothing in it that limits your future severance, that gives the company the right to change your job or pay, to give the company the right to put you on a temporary layoff. The company can't do all those things unless you sign an employment agreement that gives them the power to do it. So be very mindful. Too many people, when they start a new job and they're looking at that employment agreement, are looking at three things: how much, what's my salary, how many weeks vacation do I have, and do I have a bonus? Or maybe they look at, do I have sick days? That's it. Those are important. Absolutely, you want to look at that. But wait a second. What about, does the company have a right to change your compensation? So you may say, well, I really want to get a job that pays $65,000. I negotiated really hard and I got my $65,000. But what if that employment agreement also says, yeah, we'll pay you $65,000, and then 3 paragraphs later says, we have the right in our discretion to change your compensation? Essentially, what you're agreeing to then is to work for a company and get paid whatever they want to pay you. Not so good. So pay attention to everything in the employment agreement, or better yet, have me see it. Let me know what it's, let me show me what it says, and I can tell you what it means, and even discuss how to best negotiate it. All right, this is going to be the last question for today from Donald. Does getting let go in a massive company restructure mean you are owed less? No, absolutely not. So very important. When it comes to your full termination entitlements, whether you work for a massive company or a small company, your full entitlements are going to be the same. Doesn't matter the company's payroll, doesn't matter the number of employees. What matters is the factors that have to do with you: your age, your position, the length of your employment. Now, your minimum termination entitlements may be different depending on whether you work for a small company or a large company, but who cares about that? Your full entitlements, which is really all that matters, are the same. Whether it's a massive restructuring or you're the only person being let go, ultimately we're going to look at your age, your position, the length of your employment, a few other factors as well to assess what you're owed. And depending on those factors, you could be owed up to 24 months pay, in some cases even potentially more than that. So, Donald, hopefully that helps. Guys, this was a great session. Always a pleasure to be here. Always get great questions. One of my colleagues will be here on Thursday, tomorrow, 2 p.m. Eastern. This will be Jeremy Herman to talk about employment law, so you can ask him questions. I'll be back next week as well. But don't wait until then. If you have questions, you want to follow up. If you've asked me a question, I've asked you to follow up, do that. Just go to employmentlawyer.ca, connect with me, and I'm happy to talk to you. Guys, thank you so much for being here today. Always a pleasure. Stay safe out there. We'll talk soon.